Okay.
Yes. Dhruva, please start.
અને બધા
Good evening, everyone.
કે as far as arbitration
एक minute, sir.
is concerned,
Yes, sir. Just a minute.
earlier 19
Sir, एक ज minute. Huh? Yes, Dhruva.
Good evening, everyone. I'm today's moderator, Dhruva Shah. I welcome you all. I'm honored to introduce the Patron-in-Chief of Sambhav Initiative, the Honorable Justice C.K. Thakkar. He is a former judge of the Supreme Court of India. He was born on November 10, 1943 in Mandar near Porbandar, Gujarat, India. After taking primary education at Madhavpur, Thakkar graduated from a college in Junagadh and obtained a Bachelor's of Law from a law college in Jamnagar. He also obtained a Master's of Law from Gujarat University and began participating from 1968 in High Court of Gujarat. He was elevated to Judge of the High Court of Gujarat on 21st June 1919. He was further promoted to the Chief Justice of High Court of Himachal Pradesh, Shimla on 5 May 2002 and transferred as the Chief Justice of High Court of Judicature at Mumbai on 31st December 2001. He was appointed a judge of the Supreme Court of India on 7th June 2004. He was also acting Governor of the state of Maharashtra from July to October 2002. Justice Thakkar sir has written several law books such as Lectures on Administrative Law and Code of Civil Procedure, which remains a standard for law students in India for more than 25 years, sir. We are honored to have you, sir, today, sir. Now, I would like to invite Justice C.K. Thakkar, sir, to move further with today's session. Over to you, sir.
all, and I'm sorry that there was some problem, a technical problem as far as the hearing is concerned, but I may say that in 1940 there was an act of arbitration. You also must be aware of everything. There were several pitfalls and drawbacks in the said act. Meanwhile, UNISL had prepared a scheme, and it was for almost all countries. On the basis of such scheme, several countries have prepared their laws, and as far as India is concerned, we are having Arbitration and Conciliation Act 1996. ઘણા વર્ષો થઈ ગયા છે. આ પ્રમાણે આર્બિટ્રેશન ચાલે છે. કેટલાય એવોર્ડ થઈ ગયેલા છે અને હાઈકોર્ટ સુપ્રીમ કોર્ટ સુધી પહોંચી અને ફાઇનલ પણ થઈ ગયેલા છે. I may tell you only one thing, that as far as all positive factors are concerned, બધા સિવિલ કોર્ટના જે છે એ એના પાવર્સ વગેરે વગેરે બધું જ આર્બિટ્રલ ટ્રિબ્યુનલ પાસે છે, and arbitral tribunal can decide in accordance with law. સાથે સાથે એ પણ રાખેલું છે કે જે procedural aspects હતા, which took long delay in civil courts, in first court, thereafter in second court because first appeal, then in certain cases there was the second appeal, and then Supreme Court. એ બધા જ લેજિસ્લેચરે વિચારીને એમ કહ્યું કે નહીં ભાઈ.
Sir, can you speak in Hindi or English? Because major participants are not able to understand Gujarati.
I see. As far as the procedural aspect is concerned, the Arbitration Act makes it clear that strict rules of evidence, strict rules of civil procedure, they would not apply. Mind well, it is not that even fundamental principles of law, say for instance, Civil Procedure Code or Indian Evidence Act or principles of natural justice and fair play, they would not apply. They would certainly apply. Strict rules or in stricto sensu it will not apply, meaning thereby that the arbitral tribunal is not bound by those rules. The resultant effect is
I think voice is not coming. Hello?
Hello. Yes, sir. You are audible.
in such a tribunal, orders are passed. In the first meeting itself, it is stated normally within how much period statement of claim. Statement of claim means you may find equivalent to claim. So statement of claim to be filed within a particular period. Statement of defense. Statement of defense means virtually it is written statement. So statement of defense to be filed within a particular period if the defendant or respondent intends to file counterclaim, as it is said in Civil Procedure Code. So counterclaim can also be filed. Then after some time, the pleadings are complete. As far as documents are concerned, there would be admission and denial of documents. You can say that I deny the documents in its toto. That is, existence is also denied, contents are also denied. You may say that I admit the document, but contents therein I do not agree and I deny. Ultimately, it is for the other side to prove by examining his witness. Then points for determination. Points for determination are virtually in the nature of issues. The student who has studied the Code of Civil Procedure must be aware about issues. Issues are mainly controversies between the parties. And though Civil Procedure Code provides or states with regard to issues of fact and issues of law, normally it is judicially accepted that issues are of three kinds: issues of fact, issues of law, and mixed issues of law and fact. Like civil court, here in arbitral tribunal also, such issues or points for determination can be framed. Such issues or points for determination have been framed. Thereafter, on the basis of such issues or such points for determination, parties will lead evidence. They will be given an opportunity to lead evidence. The other side will be given an opportunity to cross-examine those witnesses. Then both the parties can request the court or request the arbitral tribunal that you may hear the parties through their lawyers. Normally, no arbitral tribunal will say that we will not allow you, and parties are heard through their lawyers. Judgments also can be cited, written submissions can be filed, and thereafter the tribunal will pass final order. Main advantage in arbitration proceedings is that it is not strictly governed by rules of evidence and civil procedure, which will result in expeditious disposal of arbitral proceedings. Thereafter, right of appeal, that is, you can challenge the award passed by the tribunal. But mind well, here also legislature has taken care of the situation that it is not like Section 96. Students who have studied the Civil Procedure Code must be aware about the ambit and scope of Section 96 of TPC. Section 96 allows first appeal to be filed against decree passed by trial court on all grounds. In fact, there are judgments to the effect which say, and it is settled law, that appeal is continuation of suit. So each and every point or all points which can be taken by the plaintiff in his plaint as well as at the time of hearing, each and every point which the defendant has taken in written statement and at the time of his defense can be taken at that time in the first appeal also. But scope of appeal under Arbitration Act is very much limited. And here also, legislature has taken care that if two views, even if fair, if one view is possible, obviously there is no question of allowing appeal. But even if two views are possible, and the view taken by the arbitral tribunal is say reasonable, then the court will not interfere. Now, the execution is also in that sense it is a decree, so immediately it can be executed like a decree, a deemed decree, and that is how the Arbitration and Conciliation Act can be implemented. So it is really a very good act, and it will also help civil court in lessening the burden. So I think that parties must accept this suggestion that Arbitration and Conciliation Act such provisions should be made in the agreement, and if there is an agreement and it is stated with regard to Arbitration and Conciliation Act and provisions with regard to following up, then the parties must go to arbitral tribunal and get the case decided by either by sole arbitrator or by three arbitrators as the case may be, which will help not only the parties as well as commercial world, but also our civil court, which is overburdened. So this is a wonderful piece of evidence, this statute, and people must try to do as far as possible under that act. Thank you very much.
Thank you so much, sir. Now we open the floor for the question. If anyone have any question, you can raise your hand and ask question to the sir. Your voice is properly audible to the sir.
Yes.
Participants, now we open the floor for question and answer. Okay. Now hope you are able to unmute yourself. Yeah. Now participants, you are able to unmute yourself.
Hello, sir. It's Mahesh.
Yes, yes, Mahesh ji.
Sir, as you just conveyed a message, like the evidence is not considered completely in the tribunal court hearings, or like then what are the key functionalities or the functions to what they consider in providing the judgments?
I tell you that as far as evidence which has been led either by the claimant, that is plaintiff, before the arbitral tribunal, or by the defendant, who can be said to be respondent, tribunal is bound to consider such evidence. Because tribunal is, as I had told you, tribunal is virtually a court. So, as you say, if it is not considered evidence of claimant or evidence of respondent, then you can challenge the award, and in all probability, the award will be set aside that it is not considered by the tribunal.
Thank you, sir.
Hello. Hello.
Yes.
Yes.
I just wanted to know where the appeal lies from the arbitral tribunal.
That also depends. See, if as far as Gujarat High Court is concerned, it is stated that if the arbitral tribunal has been constituted by the Chief Justice because Chief Justice has the power. Then, after the award passed by the arbitral tribunal, the appeal would lie to High Court, and High Court will decide it. But if it is by consent of parties, or if there is a clause, and as per that clause, without entering into, without going to High Court, if such appointment is made, in that case, the civil court will have to jurisdiction. As far as Ahmedabad is concerned, it is in the city civil court at Ahmedabad.
Thank you,
Thank
sir.
Yes, Kalpesh sir. You can
Yes.
take question from chat box.
That's Amitabh Doshi, over to you.
Hello. Can you able to hear me, sir?
Yes, yes, yes.
I can hear you.
Yeah, yes, sir. I am Amitabh Doshi from the Chennai. My question is a little different from this arbitration. Actually, sir, in state mediation, we have settled the issue and we have drafted the settlement agreement. But after the 6 month, the party has failed to obey the settlement agreement. Now, what is it becomes a decree, right, sir?
If there is settlement through mediation, then Mediation Act, which has come into force, says that it is a decree.
Yes,
But
right.
if it is not agreed, then it doesn't become decree.
No, it has been agreed and we have signed the settlement agreement also.
Decree, and it can be executed. There is specific provision also to that effect. Huh?
Where to we have to execute actually? We have to file into the High Court or how to execute, sir?
Yet I tell you, it depends upon from where it has come.
We are in from Chennai actually.
Even court can pass the order with regard to mediation.
Okay, okay. Court can pass straight away?
That it can be passed, then accordingly it can be executed.
Okay. Thank you, sir. Thank you so much, sir.
Yes, next Mohammed Akram.
Sir, my question is pertaining to Schedule 4, which prescribe the maximum fees of arbitrator. So I
Right.
just want to understand whether the arbitrator can charge lesser fees than prescribed in Schedule 4, or one has to pay in accordance with Schedule 4 only, because in some cases arbitration clauses are there. But it practical difficulty comes when the client or the parties cannot afford to pay the fees as per the Schedule 4. So can we have relaxation in that aspect, or it is discretionary power of the Honorable High Court while appointing under Section 11?
I will tell you. See, after the judgment of Justice Chandrachud, as his lordship then was, and other judges, see, as far as Arbitration Act is concerned, if arbitral tribunal has been constituted in accordance with the provisions of Arbitration Act, then they have said that it must be in accordance with Schedule 4. Now, Schedule 4 prescribes there to X3, X plus 1, X plus 2, etc. And it is also stated that if there is a counterclaim, then counterclaim also will be treated as independent claim. Then it is double fee. As you say, suppose there is the party is not in a position to pay such fee, means because of its poverty or because of its the economic condition, it is always open to arbitrators, sole arbitrator or all the arbitrators when there are more than one, that is 3. That's all right. We may not charge this much, but instead of, say for example, hypothetical, it comes to 2 lakhs each. Instead of that, they can say that all right, we will accept 1 lakh. Similarly, the Supreme Court has also said that it is open to parties to agree with regard to further fees also, because sometimes the matters are so complicated that it will be very difficult, and it may happen that in a given case, the fees which has been prescribed may may virtually come to nothing. In such circumstances, if the parties agree, then the tribunal, sole arbitrator or three arbitrators can charge more also. But normally in such matters or in such cases, in the minutes themselves, the tribunal, sole arbitrator or three arbitrators will mention that parties have agreed that on the facts and in the circumstances of the case and considering the questions which have been raised, the parties have agreed that over and above this fourth schedule, they will pay fees as fixed by the tribunal, and then the tribunal may recover or may charge more fees. Similarly, it can charge less fees also. Huh?
Thank you very much, sir. Sir, one more question connected to arbitration, if admin permits. May I ask?
Yes, yes.
Yes.
Yes. Sir. Yes, sir. I have one question. If there are multiple connecting disputes between the parties, now if one isolated dispute is governed by the arbitration clause, but second of disputes which has certainly given rise to the particular dispute which is governed by the arbitration clause in the agreement. So, can one party initiate the arbitration on the basis of that isolated dispute by ignoring all other connecting disputes, or means what would be the situation in such cases? For example, if there is an agreement between the parties, and one party is not complying, or one party is involved in some criminal act with another party, for that purpose they have already initiated some criminal complaint, or they have filed a criminal complaint, but and that is something which has been some fraudulent act with the other party. Now one party wants to initiate petition by relying on the isolate dispute which is governed and covered by the agreement. So in such cases, whether the arbit
So,
Hello. Yes,
hello.
sir. Yes, sir.
See, as far as criminal matters are concerned, arbitral tribunal, you must concede one fact, you must keep in mind one fact, that it has no inherent powers. It is not a civil court. It has no plenary jurisdiction as civil court or criminal court possesses. So, arbitral tribunal gets jurisdiction only from the parties' consent, which is reflected in black and white in terms of agreement entered into between them. So, whenever the question arises as to with regard to jurisdiction of arbitral tribunal, the arbitral tribunal, sole arbitrator or three arbitrators will go to that clause. That clause will be interpreted. Both the sides may make their submissions, and if it is only in respect of that agreement that award can be passed, which can be challenged by any party, that's a different thing. But there is no question of going to criminal, or similar questions are there in other agreements. Sometimes they may also feel that all right, there are 5 contracts, all right, best is that in one we may say that all right, do it. Each and every would be different as per agreement and consent of the parties. Yes.
Thank you, sir. Yes, Kalpesh ji.
Thank
Okay,
you.
next.
Very
Okay, thank you. Next, Mukesh Pannalal. You wanted to ask any question? Mukesh Pannalal.
Good evening, respected sir.
Yes.
Yes.
Yes, sir. My question is this: based on the notice received on the arbitrator, can the FIR also can be lodged?
Normally, there is no question of initiation of criminal proceedings, and criminal proceedings can be initiated only in criminal court.
Okay. Thank you, sir.
Yes, any further question, participants?
So thank you very much. And Hiranshi and all colleagues, they deserve congratulations for doing this and continue to do this. Huh?
Thank you so much, sir.
Okay.
Thank you everyone, and hope you learn something, even though in virtual presence of sir, but he's present on phone call. And if you want, we arrange some another session in detail or Arbitration and Conciliation Act. Actually, today's our keynote speaker, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, is facing some technical glitch, so we just find a middle way to get some learning from him. Thank you everyone. If you have any question or anything you want to share, you can.
Hi, ma'am. It's Mahesh here. Ma'am, if we get some practical aspects like how this tribunal cost cases proceedings, because we are from the college,
That,
few
yeah,
few are
that
from colleges.